Good morning, folks. And thank you all for joining us today for the basics of nonprofit bylaws, policies, and procedures. At the heart of every nonprofit and charity lies its bylaws, policies, procedures, and its incorporation or charity status. These foundational legal frameworks govern what nonprofits can do and what rules they must follow. And so it's crucial to understand their inner workings. That is exactly what we will spend some time diving into today. My name is Sandeep. I am the manager of education here at IntegralOrg. My role is to support your participation today, so please do not hesitate to reach out to me in the chat. To support your accessibility needs today, you can turn on the closed caption feature on the bottom of the Zoom window. The live transcription option will help you follow along. Please note that these closed captions and live transcriptions are auto-generated by Zoom and therefore have the potential for inaccuracies. However, they're still a great tool to help you follow along with today's speakers. I'm going to drop a link in the chat for some more information about that and just how you can get that going if you run into any challenges. Your engagement is important to us, so please feel free to drop any comments, questions, or concerns that you have along the way. We'll come back to any questions during the Q&A period at the end. We'll begin today's session with a land acknowledgement. We would like to acknowledge that IntegralOrg is based out of Mohkinstsis, which is the Blackfoot name for elbow. This refers to the confluence of Elbow and Bow rivers that run through Treaty 7 territory. Mohkinstsis is situated in the traditional territory of the Blackfoot Confederacy, which includes the Siksika, Piikani, Kainai, as well as the Stoney Nakoda First Nations, consisting of the Chiniki, Bearspaw, and Goodstoney First Nations. Mohkinstsis is also home to the Tsuut'ina First Nation and the Métis Nation of Alberta District 5 and 6. At IntegralOrg, our team recognizes the existing tension between the legal and governance structures that we work within and efforts towards truth and reconciliation. We accept our responsibility to work towards reconciling this tension, and we understand that we all have a connection and responsibility to the lands that host our lives, our communities, and our work. With that, I'm happy to introduce our facilitator for today's session, Yvonne Chenier. Yvonne is a lawyer and philanthropy consultant and co-founder of IntegralOrg. She brings more than 35 years of experience helping those in the philanthropic, nonprofit, and social enterprise sectors as general legal counsel and as an advisor on organizational, regulatory, and governance matters. Yvonne, thank you so much for being here with us today. I will pass it over to you.
Thank you very much, Sandeep, and welcome everybody. Some of you are familiar to me and some are new. It's nice to have more friends join us for information and education at IntegralOrg. So I love doing this session about the basics of bylaws and procedures and governance documents for organizations. And what I always say is before we learn the basics, we have to understand the how, the why, and the what of an organization. So I'm going to talk a little bit about that first. So before you understand what your governance documents actually need to say or what they do say, you need to understand where you come from and why these documents are created and under what authority. So I'm going to just talk a little bit about the legislation that applies to your organization. How do you know what governs your organization? Well, it's the legislation initially. Then I'm going to talk about the objects or the purposes for which your organization was actually created, and how does that relate to your bylaws, your policies, and the procedures that you need to have at your organization. Talk a little bit about the elements of bylaws and what are some common elements that we see in bylaws today and under the various forms of legislation that you could be incorporated under. And policies and procedures, why do we have them? Where do we put them? And why are they so important? So I'll talk a little bit about all that today. So let's go to my favorite little bubble chart here, which talks about governance at the very high level. So as I indicated, I'll talk about the incorporating legislation, First order of business for your organization, your incorporation documents, what are they? The bylaws, this is what we're going to talk about today, how they apply in your situation based on where you come from, and the policies that will help you implement these bylaws and everything above them. So let's go right into the incorporating legislation. In Alberta, we are in Alberta, so we will be talking about what applies in Alberta. So commonly in Alberta, organizations that are nonprofits are incorporated under either the Alberta Societies Act, the Alberta Companies Act Part 9, or the Canada Not-for-Profit Corporations Act. And each of those legislations has different wording and creates organizations for different reasons. So I've given a little summary here. The Alberta Societies Act, which many of you may be incorporated under, you have to be incorporated for any benevolent, philanthropic, charitable, provident, scientific, artistic, literary, social, educational, agricultural, sporting, or other useful purpose, but not for the purpose of carrying on a trade or business. That's right in the Societies Act. The Alberta Companies Act Part 9, that's the nonprofit section of one of our old corporate statutes in Alberta. You are incorporated if you're a nonprofit for the purpose of promoting art, science, religion, charity, or any other useful object. Then the most modern legislation we have in Canada, the Canada Not-for-Profit Corporations Act, this allows the incorporation without share capital for the purposes of carrying on legal activities. So as you see, we go from the very narrow definition of what you incorporate for as a nonprofit under our Societies Act to the more modern Canada Not-for-Profit Corporations Act, where you could be incorporated for any basic nonprofit purpose as long as you're carrying on legal activities. That's what the legislation says. So you are governed by one of those legislations. So let's see how you find out. Some people say, well, I'm not sure what I'm governed by. So the topic of what you're governed by leads into the object. So when you need to know what legislation you're governed by, it obviously helps if you know what the objects are of the entity that you created under this legislation that fall into those definitions that I talked about under the 3 different examples of legislation I used. But how do you find them? Well, your incorporation documents contain your objects or your purposes under the legislation you're incorporated under. So if you're incorporated under the Alberta Companies Act, you have a memorandum of association that lists the objects that you're incorporated under and is in fact your main incorporating document. If you are under the Alberta Societies Act incorporated, then you have an application for society where you stated what your objects are. And if you're under the Canada Not-for-Profit Corporations Act, your incorporation documents consist of articles of incorporation where you stated what your purposes are. The modern legislation uses the term purposes. The older legislation, such as the legislation we have in Alberta, uses the word objects, but we use them interchangeably. They're basically the same thing. You could be created by a constitution. So this would mean that you're not necessarily incorporated, you are constituted for a nonprofit purpose. And as such, you would list what your objects or purposes are in your constitution documents. Then in Alberta, you could also be created by legislation. So there could be an act of the government of the Legislative Assembly of Alberta that actually created your organization and incorporated your organization in that way. There are many examples in Alberta, and I'm not sure if any of you fall under that, but if you do, your objects are found in your legislating documents. Then you could also be settled by a trust. In Alberta, some charities, some nonprofit organizations are settled by a trust where the objects or the purposes of the trust are listed in the deed of trust. So all of these documents are important for you to not only understand where you were incorporated under and what legislation, and look at the documents that created your organization, but look at the objects for which your organization was created that are definitely listed in those initial documents. Very key to understand that. And a little bit of Latin here for organizations. And I like to emphasize the importance of objects or purposes, because there's a doctrine that's literally called ultra vires, and it means, this is what it means in corporate law. It describes any acts that are attempted by a corporation that are beyond the scope of powers granted by the corporation's objects clause, the articles of incorporation, or in a clause in its bylaws, that or in the laws, the legislation that authorizes a corporation's formation, or similar founding documents such as the trust deed we've talked about, or the Constitution. So basically, the whole essence of the objects leads to the fact that you've stated your objects in your incorporating document or your creation document, and you need to stick to your objects, because if you do anything that is outside those objects, technically you are ultra vires what you were created to do. So all of this leads into a little bit of a discussion about charities. Okay, I know some of you are charities and some of you are not, but the whole discussion about objects and purposes and what is contained in your incorporating legislation becomes very, very important if you want to be, or if you indeed are incorporated, to have objects that are charitable in the way that the law considers objects to be charitable. So if you do want to have charitable status under the Income Tax Act, and why would you want to do that? Just generally, it's to be able to issue charitable tax receipts to donors who give you funds, or to take on projects where other funders are funding you that only fund charities. There's a lot of reasons why organizations want to get charitable status, but you must have these purposes, or remember, objects that are exclusively charitable in law, and you must carry on activities that support those purposes. So this is the doctrine of ultra vires again. You have to state your charitable purposes, and then all your activities have to be in furtherance of those purposes. So just a general little thing, although we could go on and on about the importance of your documents for charities, but your purposes describe the aim or the main intent of your organization, but the activities describe how the organization will actually accomplish those objects or purposes. So just when we're talking about charitable, I always like to mention to people that the term charitable is not defined in our Income Tax Act, even though that is the legislation that bestows the charitable status designation on registered charities in Canada. But the courts generally define charity within 4 categories: relief of poverty, advancement of education, advancement of religion, and certain other purposes that benefit the community in a way that the courts have said is charitable. Not that you and I think is charitable, but the courts have said is charitable. Very limited list of those entities, such as, our arts organizations, appreciation of the arts, our hospitals, our health and wellness organizations. Those are all charitable, that in a way that the courts have deemed to be charitable. So our Income Tax Act does bestow charitable status on those organizations that have those kind of objects. So your purpose must fall within one of these categories to be considered for registration as a charity. So your objects are so important, and you should know what they are, because they have a lot to do with what kind of bylaws you will have too. So let's talk a little bit about bylaws. The next bubble is the bylaws. which is what we're here to talk about today, bylaws and procedures. So what exactly are bylaws and how do you find them? Well, you find the bylaws, and this is important, just like I said, how you find your objects by looking at your legal documents. You find your bylaws by looking at the place where you incorporated would insist that you file them with the registry. So societies, Alberta Corporate Registry would have a copy of your filed bylaws that were approved by the members of your society and accepted by the Registrar of Corporations. So those bylaws would be filed at the corporate registry, and those are your official bylaws. Not the ones that maybe are floating around in drafts somewhere on your system, but the ones that are actually in corporate registry are your bylaws. If you are a Part 9 Alberta company, you don't have bylaws, you have articles of association, and those too are registered in Alberta Corporate Registry as the official copy. If you are under the Canada Not-for-Profit Corporations Act, you get your bylaws that are filed. They need to be approved by the members of your corporation and filed at corporate registry, and you can download them from the Corporate Canada site. So that's where you find those bylaws. So there's official bylaws that you need to put your hands on to see what your bylaws are. So those are the bylaws. They're the laws that your organization has officially adopted in the process that your incorporating legislation states you have to adopt, and you've adopted them as the laws that govern your organization. So simply, that's what bylaws are. They're the laws by which you have to govern yourself. So drafting bylaws is it's an art, and it's important for organizations. Just think of how much time and effort is spent on drafting laws that affect us in our day-to-day life by various levels of government. There's a lot of thought and a lot of deliberation, and sometimes a lot of debate that goes into these laws. Why? Because laws affect people. And in your case, you should think about the laws that you are creating for your organization, that you create within the boundaries of your objects and your legislation that governs you. You are creating laws for your organization that basically are filed, and they are your laws. So it's very important that you draft them with that in mind. So it's fun to draft bylaws, but it's also difficult sometimes to get everyone's point of view incorporated into the document at the end. But it happens. I'll talk a little bit about model bylaws because, I think, let's be frank, most of you probably don't get up every morning and think, oh, this is great, I can draft bylaws today, like I do. But you might say, oh, well, let's just borrow bylaws that we know such and such organization uses. Or look, we can do a Google search and we can come up with bylaws that look like they might fit our organization. Why don't we just adopt those? My caution there is, number one, the organization that you are familiar with, that you might just grab their bylaws, they may not be incorporated in this under the same legislation you are. The Google search you do, you might find wonderful bylaws from a corporation incorporated in the state of Delaware. So these would not necessarily be applicable to your organization incorporated under the specific legislation that you are incorporated under. And there are some pitfalls here if you do adopt bylaws that are in contradiction to your legislating or your legislation that created you. So I'll just give some examples. Under the Alberta Societies Act, and I will talk a little bit about some of the provisions that are required under that act. You have to have very specific provisions in your bylaws, or else Service Alberta Corporate Registry will not accept them for filing. So it doesn't help if you've got your members to approve bylaws that you then submit to Alberta Corporate Registry and they're not accepted because they're not in compliance with our act, with the Societies Act. The the articles of association that are quasi bylaws under the Companies Act are a little bit different and a little bit more complicated. But generally, the Service Alberta Alberta Corporate Registry does not analyze them like they do Societies Act bylaws. However, the general rule is that your laws cannot contradict your incorporating legislation. So there's no point in putting something in your bylaws that you might rely on to your detriment if your incorporating legislation does not allow you to do so. And a good example of this is under the Modern Canada Not-for-Profit Corporations Act. When the legislation was initiated in 2009, and all organizations had till 2014 to move into that legislation if they were incorporated originally under the Canada Corporations Act, as nonprofit organizations, they prepared model bylaws. So they prepared model bylaws that you sort of click and you create your own bylaws. And these are wonderful bylaws that comply with the act, but they only comply with the Canada Not-for-Profit Corporations Act. They don't comply with the Societies Act. They certainly don't comply with the Canada or with the Alberta Companies Act Part 9. So those model bylaws are really good. And basically the Canada Not-for-Profit Corporations Act, the modern legislation, is so prescriptive that you need little in your bylaws if you will just rely on the provisions of the act that govern you. So when people detract from those model bylaws and what is in them, or don't use bylaws that have been prepared by a professional familiar with the provisions of the Canada Not-for-Profit Corporations Act, you could prepare bylaws for your organization inadvertently that contradict the provisions of the Canada Not-for-Profit Corporations Act. And they will be accepted by Industry Canada, Corporations Canada, because they don't look at the bylaws, they don't analyze them, you just file them. So I've come across situations where organizations incorporated even under that legislation have bylaws that don't really comply with that legislation. So they've adopted laws that are in contravention of their own legislation. And remember what governs, the legislation is the first thing that governs you. So you don't want to get into that situation because it does cause issues if there's a dispute in the organization as to what your laws are. And there are disputes. That's what laws are for, to solve people's disputes. So I hope that was a good overview of the little steps that you have to think about as you sit around the table with your committee and say, hey, we need new bylaws. Where do we start? Well, where you start is your legislation, your objects, what laws you want to create for your organization to enable you to do your objects, to do your purposes, and comply with your legislation. Way too legal. I know. So let's get into some of the little details on common bylaw provisions. And I'll talk a little bit about that because there's lots of different opinions on what should go in bylaws today. And there's issues that we've seen working with bylaws for years in the nonprofit area that we can use our experience to say, oh, we don't want that to happen to our organization. So the first one is membership. In Canada, nonprofit organizations pretty well uniformly all have members. This is unlike some jurisdictions, like some states in the United States, for example. So in Canada, the structure is sort of copying the business corporations structure, where there are shareholders that elect directors to govern. So the shareholders are the owners that control the organization, and the directors are the ones that are elected that govern the organization. So in the nonprofit world, all our legislation refers to members, and those are sort of the group of individuals or organizations that are members of organizations that in effect control the organization. How do they control them? By electing the directors, by indicating what changes can be made. I'll talk a little bit about fundamental changes in a minute, but they are the ones that are the important drivers behind the bus. So membership categories are very important. So you have to give some thought to your legislation and to what kind of categories, if any, you want to create in your bylaws, because this always has to be in your bylaws. So for example, the Societies Act dictates you must say, how do people become members of your society? So becoming a member of your society, stating that in your bylaws, goes a long way to creating certainty in an organization when a members meeting has to be called or a decision has to be made to make a change, and you say, oh, that has to be done by the members, and you say, well, who are our members and how do we know? The answer is look at your bylaws. So the Societies Act does say you have to say, can members withdraw? Can they be suspended or expelled? And if so, how is that done? You have to specify that in your bylaws as to how you suspend or expel a member. Membership fees I see often in bylaws. There's no requirement to state that under our Societies Act, or under any act for that matter that I've mentioned so far. But some organizations do state membership fees, and some of them are outdated. They might be too low, they might be too high, or they may have never imposed membership fees in practice, but their bylaws state they have to. So these are things that if you don't need to put them in bylaws, why put them in? And this is, we'll get to the why you need policies and procedures, because the answer is it's better to have these kinds of provisions like membership fees in policies and procedures rather than in your bylaws, which are the actual laws that you have to follow in your organization. Rights and obligations of members of the Societies Act requires that you state what they are, and generally rights are to vote, and obligations are, you see a laundry list of obligations in bylaws. Some of them are paying fees, some of them are living up to some code or some duties that members have to do to belong to the organization. So this is, to me, the most important thing you need to direct your mind to in bylaws is creating your membership structure, your framework. Then the other thing that you see in bylaws is directors and officers. How do these people get there? How do they get appointed? What are their qualifications? Can they resign? How do they get removed? Who fires the directors? The Societies Act requires that you state what the roles of the directors are, the duties, and what are their powers. There's some general clauses that organizations can put into bylaws that cover a lot of things, and then they can deal with specifics in their policies and procedures. But you need to put this general clause in there, or else Service Alberta won't accept your bylaws, for example. So it's very important that you look at how are the members electing or appointing the directors, and how are they removing them, or maybe they're not appointed by the members at all. Directors could be appointed by some third party potentially. There's all sorts of ways for directors to be appointed, but generally it's by the members. But you need, whatever it is, you need to put it in your bylaws, because that's the law by which you will govern, your organization will be governed in electing their directors. Officers are a different thing, and I'll just spend a little bit of time mentioning that you see all kinds of scenarios out there for nonprofit organizations. The one common one is for the members to elect or appoint the directors, and then the directors themselves decide who should be the president or the chair or vice chair, who should be the secretary, the treasurer, who should be the director of this or the director of that. That's one model, but that has to be stated in the bylaws that the members elect the directors, and then the directors have the power to elect or appoint the officers. So officers are those individuals who have a function in the organization. So the function, chair meetings, treasurer, look after the books and records, secretary, take the minutes, vice, step in when the chair or the president isn't around. So these are all things that are stated in your bylaws for officers. The other model is where the members elect the directors and the officers. So at a AGM, the individuals run for not only director, but they run for president or treasurer. I want to be the treasurer of the organization. So this would be stated in your bylaws as to that model. The other model is where um, even though there's people elected by the members at an AGM, it's potential that all the officers do not have to be directors. So these people performing functions as officers, treasurer, secretary, some of them can be appointed from outside of the organization. So you could have officers that are people who come in who are not members or directors, but they come in to perform the function, such as secretary, come in and take minutes of the meeting, for example. The treasurer come in and oversee the finances of the organization. So there's all sorts of models out there, but you need to find the one that works for you. And the most important thing is you got to put it in your bylaws. Especially if you are a society, this must be in your bylaws all about how directors and officers are elected, removed, etc. Committees, there's nothing in the Societies Act or in any other legislation that makes you put things about committees in your bylaws. You can if you want, but generally it's probably best to just give your directors the power in your bylaws to create committees. If you have an organization where you absolutely want standing committees like finance and audit, governance committees, etc., then you could put it in your bylaws that you must have these committees. Otherwise, you can just leave it up to the directors to make these committees as they go. Policies, well, you don't need to talk about your policies in your bylaws, but it's a good idea to give somebody the power to create policies, such as your board of directors. Your directors could create policies and adopt them and repeal them as needed. It's good practice to put that power in the bylaws. It's not necessary, but it is good practice. So the directors know they have the power to deal with making policies. So that's sort of a philosophical comment I want to make. If these bylaws are the laws of your organization, then those of you sitting around the boardroom table are probably looking for the laws. You're looking for the laws, and you take comfort if you see a bylaw that says you have the power to create a committee, or you have the power to hire staff, or you have the power to do all this. Even though at law, you as directors, you would have the power to do it because you're running the organization, you're governing the organization. But there's some organizations say they want to put more in their bylaws so their directors don't have these questions. Some organizations say, no, we understand what we can do. We want as little as possible in our bylaws. Why? Because the bylaws have to be changed with the permission of the members all the time. So if you don't want to go through the process of making your members gather to deal with bylaws, then let us keep things as simple as we can. Okay, and someone must be in our meeting writing on my screen. It's not me, by the way. um, I didn't finish on my big one, remuneration. Just let me talk about that. The Societies Act does require that you indicate if your directors and officers will be remunerated, paid. And there's a lot of confusion around that, but what they're getting at is you have to indicate if they're being paid for being directors, not or officers, not if they're being paid because they do other things for the organization, if they in fact do and are allowed to do in your structure. So you need to state that. And then there's a whole issue of these bylaws that I'll just talk about briefly now, that Canada Revenue Agency, if they're looking at granting charitable status to an organization that has charitable purposes, they will still look at the bylaws and they will still look at some of the things that they don't like to see in bylaws if you in fact are going to be a registered charity. And one of them is remuneration. They want to see a clause that indicates that directors cannot be remunerated just for being directors. So these are sort of little tips and traps that you go through when you're creating the laws for your organization. You have to consider, well, am I going to be a charity or am I just going to be a nonprofit organization? And every province across Canada has a different way of looking at whether directors of a nonprofit organization can be remunerated. However, Canada Revenue Agency, for its purpose of charities, has its opinion that no, they cannot be if you're going to be a charity. So the other thing you need to put in bylaws is, hey, we got to meet the governors, the directors, and the members, those who are controlling the organization. They have to have meetings too, and some of them are set by legislation saying you have to deal with it, and some aren't. So you need to know what what your legislation says about all this. So directors meetings, do you have quarterly meetings? Are you going to have people attending your meetings besides directors? I mean, you can put all that in your in your bylaws, or you don't have to. You just put the basics in there if you want that are required under your legislation. Committee meetings don't have to put anything in your bylaws, but again, you might want to have that dictated in your bylaws as to what committees are being created and how often they have to meet and how do they meet, who goes to the meetings, who chairs the meetings, etc. Annual general meetings, pretty well every legislation that deals with nonprofits talks about you have to have an annual general meeting once a year, right? That's what the word annual means. So under the Societies Act, you have to have an annual general meeting. It states there in the act, and in your bylaws, you have to put around the procedure on how you are going to have that. How are you going to give notice? Who's going to attend? What the quorum is? Who's going to vote, etc. So you need to focus on that, and you should focus on that. Why? Because that's the issue that often stumps people. How do we do this? How do we have a meeting? How do we have to operate to get what we need to get done in our organization from a governance level? Well, you look at your bylaws, and hopefully the meeting procedures and meeting sections are clear. Special meetings, the Societies Act does require that you talk about special meetings and how you're going to have them, who's going to be there, quorum, the whole 9 yards. It's all in the Societies Act, and you have to specify that. Other legislation does not require that you talk about these specific things. Rules for meetings, common bylaw provisions. Sometimes you see these are like Robert's Rules of Order or other nonprofit books that are out there. Some organizations put this right in their bylaws, so everyone knows that if there's a dispute about procedure, you look at the bylaws and it says we have to follow this rule book, and away you go to the rule book. There's no requirement for you to put this in the bylaws. Sometimes it causes problems. You can use your policies for that instead. Generally, the rule about rules for meetings is a meeting is ruled by the rules that the meeting agrees they will be ruled by. But if the organization has created a law for itself in its bylaws that you will be ruled by Robert's Rules of Order, then that overrules what the meeting would say, and you must use Robert's Rules of Order. So you may or may not want to put that kind of thing in your bylaws. So the other bylaw provisions you do see sometimes, and why? Sometimes because it's driven by what the Societies Act requires. You don't need to talk about your registered office in your bylaws, but some organizations do put it in there so everyone knows that it's going to be in downtown Calgary or rural Alberta, or certainly in Alberta. It's got to be in Alberta if you're an Alberta society. If you're a Part 9 or sorry, a Canada Not-for-Profit Corporations Act, you may not even have your registered office in Alberta. You may just be registered in Alberta, and that's a whole other topic of discussion. Some organizations talk about corporate seal. Why? Because the Societies Act uses the word. If you haven't adopted a corporate seal, then you could put in there that you haven't adopted one or you could adopt one in the future. The Societies Act is looking to see if you have one, who has custody of the corporate seal. So you need to at least state someone who has custody of the corporate seal if you in fact have one. This does cause confusion, and this is one of the areas of reform that I hope to see in Alberta at some point about this whole corporate seal misunderstanding in the nonprofit world. Fiscal year end, again, some organizations put that in. It's not required in your bylaws. And indeed, if you do change your fiscal year end, Canada Revenue Agency would have to be involved in helping you make that decision. The Societies Act requires that you do a little clause about borrowing powers. Do you in fact have the power to borrow, or who does in your organization? Is it the directors? Is it the members? And the act goes further to say that if you have a borrowing issue power, you have to, if you want to do debentures, you have to get a special resolution of the members to do that. So you can't take that away from the Societies Act by putting something different in your bylaws. Minute books, some organizations talk about where their minute books are located and who has custody of other records, accounting records, etc. Why? Because the Societies Act requires that you talk about who has custody of your minutes and who will take minutes of meetings, etc., and who has custody of other records. So this is usually the job of the secretary and treasurer, and often you see that in the description of their duties in the bylaws of your organization. So all of this is to say that there's some common bylaw provisions. Some of them aren't required in bylaws. You can put them in there if they suit your organization, but you need to give some thought as to why is this, why are we making a law about this? Do we need it? Is it going to be something that's going to be a problem for us, like Robert's Rules of Order? Why do we have that law if it's going to be a problem? If it's not required, think twice. Do you need it? So those are general things you should consider about bylaws. I'm going to talk a little bit about changing your bylaws and changing things in your organization's governing documents. But I'm just going to give you an example of the differences in the legislation in something fundamental. Members. We talked about how fundamental members are to nonprofit organizations all across Canada because of the structure that we're using. So members are defined differently under each of these legislations. So your bylaws have to stick to how the legislation treats them and what requirements there are. So example, in your Societies Act bylaws, you do have to state the terms of admission of members and their rights and obligations, as we discussed, the conditions of withdrawal of members and how they're going to be expelled. So you have to state that in your bylaws. The Alberta Companies Act is wide open, and there's historic reasons for that, because a company can be incorporated and shareholders can be present. You can issue shares if your fundamental foundational or memorandum of association and provide for that. If you have members instead of shareholders, you have a simple definition in the act, and you have to put a procedure in place as to how people become members of your organization. Otherwise, the people that signed your original memorandum of association, they are the members forever until you can change them in accordance with your articles. The Canada Not-for-Profit Corporations Act, wide open. All you need to devote your attention to when drafting bylaws under that legislation, when you're talking about members, is if you have two or more classes of members, class A, class B, or voting, non-voting, you have to give the voting rights to to the to at least one class of members, but you then have to talk about the voting rights of all your classes. So this gets a little bit complicated, and there's a lot of analysis that should go into making classes and groups of members under the Canada Not-for-Profit Corporations Act. So it's very important to address your needs of your organization in your unique circumstances before you just slap clauses in about members under that legislation, or indeed any legislation. So very important that you have to consider your legislation when you're changing your bylaws in many areas, and this is one I've highlighted: your members. Lots to think about. Lots to think about. So let's talk about policies. So why would you have policies? Well, look at our little hierarchy here. So you have the incorporating legislation, which you all know is your big overriding rule of what you have to live up to. Your incorporation documents state a whole bunch of things: purpose, objects, and many other things too that you would notice if you looked at them. Then your bylaws are the laws you create. So all of these are sort of conceptual things. You need to bring them down to the level of your organization, what your organization uniquely needs for you guys to do to implement all these things that are on top of you. So that's my way of looking at what policies are. So the important thing about policies is they help you manage the minutia of your day to day, right? And when you are an organization doing anything, every time you take an action, you are taking a step that is risky, right? Every action has a risk that it might not be the right step, or it might be the right step. But you need to have policies to make sure that the risk that you are taking in your organization not only follows your laws and everything above you, but is something that you will be able to understand and implement at your level. And I'm just going to give some examples of policies. So let's talk about roles within an organization. So the role of the CEO, for example, the role of the treasurer, the role of the fund development director. I mean, all of these are roles that you have created. Why? Because your governance documents allow you to create these positions. So you've created them in your bylaws, but you need to actually have some rules or some description on what they can do to to follow the laws that you've created. So those are common things you see in most organizations. Most of you have role descriptions for all of your positions, and if you don't, you should. There's other legal reasons why you should have role descriptions. Many policies and procedures are done around governance of organization, and one of example is financial management. In your bylaws, you do not need to state who signs the checks. You don't need to state that. But some do. Some organizations do have that in their bylaws. But even if you do, even if you do or don't, you need to have a financial management policy that says who signs the checks, what happens if they go away, what happens if they quit, what happens if it's $1 million check as opposed to a $500,000 check. So these are things that are in your governance policy for financial management, oversight, etc. That's one example. You wouldn't want to put all this in your bylaws. And indeed, I've seen issues with organizations that do put way too much details in their bylaws, meaning the laws that govern their organization. And then when it comes time to do something simple, like do e-transfers or email transfers when they were first invented, the bylaws didn't talk about that. So there was some uncertainty in, well, does this mean a check or what does this mean? How do we know who can do all that? Well, you need to amend your bylaws to refer to your financial management policy, or not talk about that kind of stuff in your bylaws at all, but make sure it's in your policies. And then there's a whole bunch of policies required by legislation. And the one I always talk about is the Occupational Health and Safety Act. You are required as an organization, whether you're a nonprofit or not, to comply with that act. And if you do look at that act or follow some of the other sessions that we've done here at IntegralOrg, you'll know that there are many policies you absolutely must have to show the occupational health and safety officer if they come in to do an audit on your organization. So these are policies you have to have. Then there are very different kinds of policies that might be specific to the kind of organization you happen to be. And one of the top ones that always comes to mind, if you're dealing with youth or you have volunteers that are youth, you need a lot of policies that protect you as to what you do and how you handle with these volunteers. So all of these policies or procedures that you're going to create, they can't contradict your bylaws. They can't contradict your legislation. They certainly have to be, done for activities and furtherance of your objects. So where do you find these documents? And again, one thing you need to know is none of these documents are registered anywhere. Bylaws are registered. I can find out what your bylaws are for any of your organization by downloading them from the appropriate registry. So that's not a problem. But the policies are documents that you have internally in your organization that to govern you. Generally, your policies are created by your board of directors if they're governance policies. Sometimes policies are created by the people who are operating the charity, the staff, if they are, authorized to do so by some delegation of authority, etc. So there's all sorts of reasons why policies are governance policies at the governance corporate level, and some are operational policies at the day-to-day operational level. You need to know the difference. Governance policies generally can be changed by the board as they see the need. And of course, operational policies are changed by whatever process you put in place to change operations policies. So I don't know where you find these documents. Hopefully you have some system that if I walked in and said, what's your confidentiality policy? You'd be able to say, oh, here it is. Where should they be stored? Well, obviously where people who need to know what the policies are can access them. So all of this is to say, I guess, on policies that they're flexible documents because they're not necessarily your laws. They're your ways of implementing your laws. So they're flexible because they can be changed by, in one example, the board of directors, or in the operational side, if it's an operational policy, they can be changed as circumstances change. You do not need to have a big members meeting to change policies unless it relates to the members and they need to vote somehow. But you do need a members meeting to change your bylaws. And if you're doing something that your legislation doesn't allow you to do, well, you need more than a members meeting to change your legislation, right? You need the government on your side. And that happens, especially if you've been incorporated under a specific legislation of the Alberta legislation. If you want to do something that you can't do under your current legislation, you can change it, which is good, with the permission of the government. So fundamental changes are things that happen in an organization under your legislation, and fundamental changes have to be voted on by the members generally. So if you change your objects or purposes, they have to be voted on. You change your bylaws or your articles of association. And if you decide to dissolve or wind up your organization, all of these are big, big things that have to be changed by convening a members meeting, and often getting a special resolution, which is a different kind of process that you have to make sure you have under your legislation, and they're different. Societies Act has a different definition of special resolution than, say, the Canada Not-for-Profit Corporations Act, totally different. And then the Companies Act is somewhere in between. So you need to know what the definition is of what you have to do to make a change to your bylaws, your objects, or wind up your organization. So all of this is a lot of governance stuff, but not a fundamental change is your policy amendment. So, so if you have all these wonderful policies and one of them doesn't work, you say, let's change this policy. And then often it's just changing the wording or modernizing it to suit your needs and having it approved by the board of directors if it's a governance policy. So it's much more flexible to have policies to govern your organization as long as they're in compliance with your bylaws and your legislation and your objects. So all this is really linear to me, but then you get to the point about procedures. And what are procedures? Well, I guess I've got all these wonderful policies, and you go, well, this is nice that we have this policy that says this. How do we do that? The policy says, we don't work 7 days a week. Okay, that's good. That's a nice policy to have. How do we do that? Well, maybe the procedure says, we lock the door on Friday at 5 o'clock and we don't unlock it till Monday at 9 o'clock. That's a procedure. Somebody has to do it to implement the policy. That's an operations policy. I've got some examples of other procedures that I'll show you at the end. So procedures, in my view, for organizations are tidy. They're like the icing on the cake to complete the governance model. That's the way I look at it. It helps you not only know the why, the who, the how, the what, but the details of what you have to do and who has to do it. So, the legislation that we've talked about today and the bylaw wording, these are all really general things that, thou shalt do this, thou shalt do that. And policies are pretty prescriptive. They say, yes, we shall do this because we need to govern our organization by having a board of directors. But that's where they stop. The detail and the procedure is, how do we get a board of directors? These are the procedural details that you can't just make up on the fly, although many organizations do, sometimes to their detriment. But if you have procedures, then they're there, the details. The devil is in the details, as they say. So in my view, procedures are step-by-step instructions, like a recipe, on how to implement policies that were created pursuant to your bylaws, that were enacted. Enacted means they became your law pursuant to legislation. And what legislation? We've all talked about it. It's not the legislation that governs the other organization. It's the governing legislation for your specific organization. So that's a lot of information. Hopefully it's given you a conceptual understanding of the legal fundamentals of the governance structure from a legislation, bylaws, objects, procedures, policies point of view. And I'm going to just give you a couple of examples so we know conceptually what might happen in your organization. And I've talked a little bit about board of directors and getting them elected. So here's an example just for any old nonprofit organization. So the nomination process is something that we're all familiar with. So the bylaws might state, as they often do, that directors are elected at the annual general meeting. And that could be the only thing that says directors shall be elected at the annual general meeting. Stop. Some bylaws go further and say that the board can create a nominating committee. So the board does create the nominating committee, or the board may have the power stated in its bylaws to create a nominating committee, or the board just looks around and says, we have the power to create committees to help us do this under law, so let us just create a nominating committee. So that's the board doing the creation of the nominating committee. So the nominations committee usually is created by terms of reference or however your organization does it. There's many ways to create these things. They go off and they create a nominations policy. So it's a policy of the organization that would be approved by the board that complies with the bylaws. What do the bylaws say? Directors are elected at the annual general meeting. That's all they say. So the policy gives a little bit about background about that statement. Then the board approves the nominations policy, and then someone say, well, this is nice. The nominations policy says we send out this, we do that, we analyze who these people are that are potential candidates. The procedure that would be implemented in furtherance of this policy has the step-by-step. 60 days before the AGM, we do this. 30 days before the AGM, we do this. Cutoff of nominations, we do this. If there's nominations from the floor, we won't accept them, and this is how we handle it. These are procedures that the chair of the meeting, potentially understands that if something is thrown in front of them, they go, oh no, our procedure is we follow this sequence of doing things. So it's good for nonprofits to have procedures in pursuance to policy on many things. This is just one example. I could think of many others, but this is just one example. And it creates certainty for your organization. There's another example for charities. So a registered charity, as I said, is a good thing because they can give receipts for donations under the Income Tax Act. That's why many of them want to be charities. So the Income Tax Act has very specific requirements for charities accepting and receiving gifts. That's the external legislative thing that they're telling you what you have to do. That's their law. So you haven't necessarily put it in your bylaws or anything. You don't need to. Why? Because the Income Tax Act that governs you as a registered charity in this case has very specific rules that you have to follow. So we all know that each charity has different needs and beliefs or capacity related to gifts. Some of them can take big gifts. Some of them have basic beliefs that they won't take certain kind of gifts. There's all sorts of reasons why a gift acceptance policy is a very good example of what is needed for charities that are made pursuant to their bylaws, their legislation, and external forces that govern them, such as the Income Tax Act. So the board creates a gift acceptance policy. Yeah, we're going to take publicly traded securities. No, we're never going to take anything that relates to environmental issues or anything like that. And no, we will not take a suitcase full of cash. I mean, these are things that the board, will talk about. Do we want insurance policies? They might just say, yes, we'll take any insurance policies. The gift acceptance policies might be very general. Some say, hey, we'll take anything. We need the money. Then the people on the front lines, I'm using the example here, the Fund Development Committee or the staff who are implementing the fund development, they have to create a procedure to implement the policy of the board. Because say the board says, no, we will not accept any publicly traded securities that are from corporations that are in a certain industry. Well, how does the development staff implement that? What is the industry? What are these shares? If they're encountered by someone who said, we would like to give you $1 million of shares of this company, and you go, oh no, that's not, we know we shouldn't take that under our policy. Is there a form letter that goes out and says, thank you for your donation suggestion, but we will not take it? So these are things that are step by step, so there won't be any surprises in the organization. When someone says, oh, you didn't accept that gift. Why? Well, our procedure, policy, et cetera, et cetera. So that's an example. I can think of many more. Charities, of course, have to have policies and procedures on a lot of things to comply with the requirements that the Income Tax Act imposes on them. So there's many other examples. So let me talk a little bit about resources here before we go on to question period. Um, there are lots of resources out there to help organizations create bylaws, policies, procedures. I've talked a little bit about bylaws, meaning, you just don't grab any old bylaws and say, these look good. It's you have to make sure that they're applicable to your organization. Um, Policies and procedures are the same. Uh, there's lots of policies and procedures out there, but be mindful that they apply to your organization. So you don't need to reinvent the wheel, but you have to be mindful that they actually will work for your organization. I always say ensure that the resource you're looking at is relevant to the legislation that you're incorporated under and the jurisdiction. So I've already talked a little bit about be wary of using Canada Not-for-Profit Corporations Act resources for Alberta societies. And certainly, the processes and policies adopted by a hospital in Nova Scotia may not be applicable to a healthcare organization in Alberta. Privacy laws are different across the country, so you don't necessarily have to think that just because you've adopted a privacy policy from an organization in Quebec and the procedures under that, that it fits here in Alberta. So you have to make sure that you always have to think, we're in Alberta. The laws in Alberta govern us. Is this relevant to the laws in Alberta? And is it relevant to the incorporation statute that governs us as an organization? And then my big bee in my bonnet always is copyright. Be mindful of copyright violations. You just cannot grab something off the internet that you see from someone's website and copy it verbatim and use it. You can't, because anything out there is protected by intellectual property rights of the author. So you have to think, how do I get permission to use this specific document? And if I'm going to modify it at all for my use, do I need to get special permission? So do have some thought behind that. And any use of someone else's IP, does have a risk associated for your organization and potentially for your own status as an employee, a volunteer, or a director of a nonprofit organization. So always think about that. I know that's probably not something that's on top of mind for many of you, but it's today it's becoming very important. Anyone can search your documents. There's a way to find everything now on the internet, it seems. Hard to keep anything a secret. So if you're in doubt about any of this, certainly seek professional advice. There's lots of it out there for sure. And again, be mindful that it's in your jurisdiction and it's relevant to the kind of organization that you are. If you're a charity, you might have totally different requirements than a nonprofit organization incorporated under the Societies Act that is not a charity. I hope that's been helpful. I sometimes think I go a little bit conceptually into outer space, but my goal always is to make you think that you are looking after a specific organization in your role, and that specific organization has its own thing that it has to do, and you need to be mindful of that thing, not someone else's thing. So that's the concept that I always like to instill. So I will turn it back to Sandeep, and she might have taken some questions from you. We have time for questions, and I'm happy to answer them if I can. If not, follow up.
Yep, folks have been engaging throughout, Yvonne. So we have a couple of questions here in the chat. Danny asks, when updating bylaws for nonprofits, charity, and society status organizations, do
Mhm.
we need to submit the updated bylaws to be approved by the
Mhm.
registry?
Mhm. Okay, that's a good question. So, um, you do. Again, I have to talk about the legislation, right? Under the Societies Act, for example, the members by special resolution approve the bylaw amendment, then it's really not official until it is filed at Alberta Corporate Registry, and Alberta Corporate Registry puts its filed stamp on it and sends it back to you. Then those are your official bylaws filed in registry. So yes, they do. Canada Not-for-Profit Corporations Act organizations have a special rule as well. The bylaws have to be passed in accordance with the requirements of that legislation by members or in certain circumstances directors. There's all sorts of nuances under that legislation. And further, within 12 months of it being approved, it has to be filed in corporate Canada Corporations Canada. So yes, they have to be filed. So again, I want to instill in you that the bylaws that are floating around in your organization that don't have an official filed stamp on them are not necessarily your bylaws. And I see that time and time again in clinics when we're talking to organizations. We're looking at the bylaws they sent us, and then I'm looking at the bylaws I downloaded from corporate registry. They're not the same bylaws. So guess what? The ones from corporate registry are the official ones, not the ones they think they're operating under. So hopefully that answers the question.
Fantastic. Another question about updating bylaws. When updating bylaws, it would follow current bylaws in place, correct? Not decided by executive members only.
I understand the concept of your question. So yes, when you amend your bylaws, you have to follow the rules that are in place to amend your bylaws. So in your current bylaws, you may have a process. You may have a whole bunch of stuff in your bylaws that say how to amend these bylaws. You must follow that. However, I will put the caution that what is in your current bylaws may not be what is in the legislation. Remember, some registries, like under the Part 9 Companies Act, they'll take stuff, and under the Canada Not-for-Profit Corporations Act, they'll take bylaws and file them. They won't look at them. So even though your bylaws say A, B, C, D, it might not be in compliance with your legislation. So to answer your question, you need to know, what do your bylaws say? And then you have to say, are those bylaws in compliance with our legislation? And if the legislation says, as I'll use the Canada Not-for-Profit Corporations Act, if it says you need a special resolution to pass your bylaws, then you do. It doesn't matter what your bylaws say. It's what the law says. So again, you have to sort of be suspicious when looking at bylaws, making sure they're the filed ones and then making sure they comply with the act.
Thanks, Yvonne. Brenda has a question. How do we determine if we are in contravention with the Canada Not-for-Profit Act
Mhm.
if they don't review and
Mhm.
accept?
Mhm. Well, that's a good question too. And guess what? You don't. You have to get professional advice, seriously, or you have to sit down and you read the Canada Not-for-Profit Corporations Act. Um, and many parts of that act do say that this cannot be changed, blah, 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 except with, a special resolution of the members, and you must state that in the bylaws. There's all sorts of nuances in that legislation. The regulations have prescribed periods for notices. They have prescribed percentages for votes, etc. And those aren't in the act. Those are in the regulations to the act. So you have to know the law and the regulations to know if your bylaws are in compliance with the act. So it's a good idea to get some information or advice about that. And I know Sandeep will talk about our clinics, and we often look at people's bylaws in our clinics, and I'm looking at them and saying, no, 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 you need to change this because the act says that. So that's the only way. I guess it's it's like any law. How do you know if what you're reading is in compliance with the law. You have to look at what the law says.
Mhm.
Big picture.
Yeah. Thanks, Yvonne. Annette is asking, can the president be a director?
That's a good question. Again, remember the president is an officer, right? The president performs a function of being a president. Sometimes the president is the one in the bylaws that is stated to chair the meetings, etc. So yes, the president can be a director, and indeed the president is usually a director, but there's no need for officers to be directors, but you need to specify that in your bylaws. You really do. It's all about the bylaws. So generally, the bylaws state that, the directors are elected, they're directors, they're governing, they're the ones legally responsible for the organization. And out of that group of directors, somebody is going to have the title of president, someone is going to have the title of secretary, someone is going to have the title of treasurer, someone's going to have the title maybe of chief bottle washer, whatever you want to create. There's no restriction on what you name people because they're functions. And generally you say, or there's some clue that I can derive from reading your bylaws as to whether these individuals that are named these offices are also directors or are they not. Sometimes these people are just employees who are given the title of president. And then they don't necessarily have to be directors. What does their employment contract say? What do your bylaws say about staff or employees sitting on the board if they do? There's all sorts of, it's like a puzzle. You ask me a question, I go, okay, I look at all your documents, I tell you the answer. So the question was, can the president be a director? I can certainly give you the answer by looking at your documents and not necessarily the legislation in this case, because that wouldn't have an impact.
Hmm. Okay, we'll move into the final question here from Natasha. Before I relay that to Yvonne, if there are any other
Mhm.
questions, folks,
Mm.
feel free to drop them in the chat now. This is your opportunity. Natasha asks, is there a minimum for number of directors and members?
That's a good question too, Natasha. No, no, there isn't. Um, it, it depends on a lot of things, though. It depends on the kind of organization you are. So for example, give some examples. Under the Canada Not-for-Profit Corporations Act, there's a couple of different kinds of corporations. I'll use one. One is a soliciting corporation, basically one that gets funds from the public, and then there's a non-soliciting corporation that doesn't get any funds from the public, just gets funds from its members. So a soliciting corporation under the Canada Not-for-Profit Corporations Act has to have a minimum of 3 directors. A non-soliciting corporation under that does not have to have a minimum of 3. It can have 1. So again, the legislation will rule. So it doesn't matter what your bylaws say. So here's a good example of bylaws that are not drafted with professional advice or in consideration of the legislation. I've run across soliciting corporations, and there's their bylaws that say, oh, we can have 1 director. Well, you can't under the legislation. So that's one question. There's no real maximum either. I can't think of any legislation that says there should be a maximum. That's a practical issue. You don't want to put in your bylaws that you can have 30 directors unless, in fact, you're a big organization and you need 30 directors. The other aspect of the whole question is whether you're a charity or not. There are rules, lots of rules about arm's length and governance and control about directors in the charity world. So again, you'd have to know if you're a charity and you'd have to know the legislation you're under to know if you are one of the organizations that is affected by needing a minimum number of directors. So there's minimum members. Again, okay, I use the Part 9 Alberta Companies Act. If you are a private company, under that act, private nonprofit company, you can have 2 members, minimum of 2 members. And the act says you cannot operate with less than 2 members for less than 6 months, or else you get a big fine. Um, if you're a public company under that legislation, again, this is really getting into complicated things. You need 3 members. So there's all sorts of weird things about that. The Societies Act, you guys all know if you're a society, the original application had to be signed by 5 people. That's what the act says. Those 5 people are the first members of the society. So the societies, to start, you need 5 members. But the minute you're incorporated, you can drop down, you can get rid of those members and drop down to 1 if you want. There's no rule about that. So there's all sorts of nuances about your question. And they can be answered by looking at the documents, looking at the legislation, and looking at the kind of organization you actually are.
Mhm. We have a question from Lauren. Lauren says, I know it depends on the objectives of your company, but in your experience, is it beneficial to have fees and enforce these fees in your bylaw, or does it more often lead to confusion or lack of engagement later on by members?
Mhm. Well, if you want your membership fees to be an absolute law and you need to enforce them, then I would put them in your bylaws. Why? Because the only people who can, and I'll use the Societies Act, the only people who can change your bylaws are your members. So if the members have agreed that there will be a membership fee, then they've all agreed by signing these into these bylaws and passing them that there will be a membership fee. So it's really easy to say, well, if you're not a member, if you don't want to be a member, don't pay the membership fee, or if you don't pay the membership fee, see the bylaws, we can get rid of you. So if that's really important to your organization, that you need those membership fees to drive your revenue, then it should be in the bylaws. Because if it's just in policy and not in the bylaws, then it's more easily changed and it's sort of maybe a little less level of authority than if it was in the bylaws. So if the members who are paying these fees don't like the policy on the membership fees, they can put pressure on the organization to lower them or delete them. Much easier if it's in policy than if it was actually in the bylaws. So anyway, there's a definite rule and there's a definite answer to the question, but often it's what do you intend? What do you really want? If you want something rigid, then we should put it in the bylaws. If you want it flexible, then let's put it in the policies and procedures. That's sort of a good way of generalizing on that one.
Mhm. Okay, so we have 2 more questions. We have some time here. So Brenda asked a follow-up question.
Mhm.
Do we need a certain ratio of members to directors as a nonprofit under the Canada Not-for-Profit Corporations Act?
No, no, no. I've seen Canada Not-for-Profit Corporations Act with 1 member
Hmm.
and dozens, a dozen directors. Again, member is the member or members under that act control the organization. So the members can create the organization, the bylaws of the organization, in the way they want the organization to be governed. So just to give you an example, there are many private family foundations that are incorporated under that legislation or indeed other legislation. They have 1 member, father or the mother, whoever gave the money, sometimes the father and the mother, and then the board is, their friends and relatives. But the members are just the people who are actually the donors or the founders of the organization. Very common.
Wonderful. So our last question for today, can you amend or revise bylaws without proper notification to members?
No, no, because how you have to notify the members so they can vote, right? There's again, look at your procedures in your bylaws and then review in bylaw amendments, you really need to review the legislation. So the Societies Act says that bylaws can only be amended by special resolution of the members. and that is clearly defined in the legislation. And indeed, you cannot change that definition of special resolution by putting any different wording in your bylaws. So I'll just whip it off quickly. Special resolution is defined in the Societies Act. It's not defined the same in other acts, but in the Societies Act, it's by notice in writing 21 days, at least 21 days before the meeting, to the members entitled to vote, telling them what you're asking them to vote on, and indeed giving them, a lot of indication, sometimes the actual written resolution proposal, so they vote, or a resolution signed by all of the members entitled to vote at a meeting. So that's a unanimous resolution. So that's a very confusing definition, but it's, if you read it and you understand it, you'll see that, members need notice, or they all have to, well, there's waiver of notice that you probably put in your bylaws, but they all have to either go to the meeting and vote or with proper notice, or they have to sign a unanimous resolution. All of them have to sign saying, yes, these bylaws can be changed.
Wonderful. Yvonne, thank you so much for taking the time to thoughtfully answer these questions. And
Try.
folks, thank you. Thank you for your engagement and for submitting these amazing questions during and throughout our time together today. So that is it for today's session. I'm going to pop a survey link in the chat for you here. When we're planning our education offerings, we refer to the feedback that you've provided so that our workshops continue to meet the needs and interests that you have. Hearing from you is how we know that we're on the right track. So if you could spare a few minutes and let us know how we did today and what your nonprofit education needs are, that would be greatly appreciated. We recognize that the questions that you have may require a more in-depth conversation about your organization. For more specific support, including legal information tailored to your organization's needs, we encourage you to access one of our free problem-solving services. This could be a short phone or video consultation or a 1-hour problem-solving session called a clinic. These meetings happen between your team and one of our IntegralOrg experts. Clinics and consultations are a part of our mission to educate and support Alberta nonprofits, so we're here to help. And you can find out more about any of our supports and services by visiting our website or giving us a call. Drop a link for you in the chat for the survey and hear more information about how to be in touch with us or how to book a clinic. IntegralOrg is a capacity builder and nonprofit ourselves, and our goal is to equip you with the knowledge and support you need to do your best work. We work in many core areas, including governance, strategic planning, risk management, legal compliance, financial management, leadership development, and more. And we work with nonprofits at any stage of their life cycle using a multidisciplinary approach to address your most pressing concerns. We're here to walk alongside you in your nonprofit development journey, so please do not hesitate to reach out to us. With that, I wish you all a wonderful rest of your day, and we hope to see you again soon.
Bye, everyone.